Good evening, everyone, and welcome to the September 23rd work session of the Ann Arbor City Council, a special work session with respect to marijuana regulation. We have before us a discussion of the proposed ordinances for the zoning and permitting of adult use recreational marijuana establishments as allowed by the Marijuana Regulation and Taxation of Marijuana Act. Mr. Lazarus.
Thank you, Mayor. Welcome, council members. We're going to start this evening with a short presentation to kind of bring everybody to a similar level of understanding where we are, to kind of define some terms and set the stage. And then with this special call work session, our hope is to allow as much time for questions and discussion as we can, as the council can tolerate. So we're going to turn it over to Mr. Leonard. While he's doing it, I want to express my appreciation to Brett as well as to Mr. McDonald and Ms. Larkham for their help over the last couple days and last week as well.
Good evening, Mayor and Council. I am Brett Leonard from the Planning Manager for the City of Ann Arbor. Joining me in this presentation shortly will be Kristen Larkham and Kevin McDonald as well from the Attorney's Office. And I just want to start very broadly. The city obviously has I would say perhaps a more unique history with marijuana than a lot of other communities, both in the state of Michigan and throughout the country. A history of involvement, be it the Hash Bash, activist groups, or pretty progressive, in some eyes at the time, municipal regulations were governing marijuana in the community. And more recently, that history has evolved through a series of legal statutes and acts. The first being 2008, which was the Michigan Medical Marijuana Act. This was opening the structure for caregivers and patients to be able to secure cards and start to use marijuana medicinally. Then in 2016, the state formalized the ability to create businesses around that industry through the Medical Marijuana Facilities Licensing Act. And then in 2018, a voter-initiated referendum was adopted, the Michigan Regulation and Taxation of Marijuana Act, or in sort of common reference for tonight, the Recreational Marijuana Act. This evolution is complex in that while it seems very logical in the steps that we have covered from 2008 to 2018, there are slight differences in some of the language, things as simple as how marijuana is defined and referenced in the acts as distinct, the types of facilities that are distinct. Are sometimes shared terms and sometimes distinct terms. And you'll notice in that slide, particularly in that last paragraph, the underlined terms are those new facilities that are established for the first time under the Michigan Recreational and Taxation of Marijuana Act. So I'm going to cover, unsurprisingly, is how we approach this from a land use perspective and recommended amendments to our Unified Development Code. And I would say you should all be congratulated that the medical marijuana changes that were made to the UDC, I think, set a great stage to consider the implementation of recreational marijuana into our ordinance as well. And we followed that lead in trying to build on the language that already existed. All is not overly complex. There are a lot of shared terms that were created and established in our UDC through the Medical Facilities Act that we have are simply recommending striking the term medical from. Facilities is a general term, and then safety compliance, secure transporter, grower, and processor. Those are going to be facilities that are going to function in a very similar land use review perspective, whether they're for medical or recreational use. But the Recreational Act does create some new terms and some new uses. You've obviously seen those at first reading previously, but we wanted to spend a little bit more time about explaining those tonight. The first is a designated marijuana consumption facility. And unsurprisingly, this is a business facility established where adults 21 years of age or older can go and consume marijuana either through smoking, ingestion, or other methods. From a land use perspective, we are carrying forward the requirement that it be 1,000 feet from a school. It is allowed we're recommending it be allowed in commercial districts because by its nature, it's a retail service use. It is customers going to access a service, and so therefore we thought it was very appropriate with other business and commercial uses. You'll recall from your first reading of this, this is now via amendments at the, of this board. It can be co-located with a provisioning center or a retailer. And again, this is a place where you can consume, but there are restrictions that you cannot sell product at this location. A new term is a marijuana retailer. While this is a new term, it is very proximate to a provisioning center under the Medical Marijuana Facilities Act. This is essentially a store where an adult can go and buy recreational marijuana. Our proposal is to, and as reflected in the proposed UDC changes, is to treat it similarly to provisioning centers, in fact, identical to provisioning centers. Again, it is a retail function. It is a commerce type use, so we're recommending that we maintain it as a special exception use in the commercial districts, and also as a accessory use when it is accessory to a larger facility in the manufacturing districts. We are proposing that the provisioning centers are sort of automatically approved now under their existing special exception uses to be retail centers as well. This is building on language actually of the state, the approved act that actually limits new applications for a time period only to existing provisioning centers that have been licensed under the Medical Act as opposed to opening it to the general public. Same standards apply, 600 feet from other provisioning centers, 1,000 feet from schools, and the intention is that the cap, which we'll get to in the attorney's portion of the presentation, is that 28 permit cap. Those 28 provisioning center caps become shared provisioning center and or retailer permits, so that it would have the flexibility to be a shared facility, or it could be one or the other, all capped at the proposed 28 permits. Marijuana microbusiness is a new facility established under the Recreational Act. This is a facility that allows the growing, processing, and sale of product directly to consumers. It doesn't allow transfer to other processing centers or to provisioning centers, nor does it allow consumption. So it's sort of the equivalent of a microbrewery where you'd have to take everything out in a growler as opposed to drinking it on premises. We're proposing this as a special exception use in the C3 district and the manufacturing districts. The nature of that is the primary portions of this use, there's probably going to be more of the floor area dedicated to the growing and processing than the retail operations. So that's why the recommendation is for those zoning districts, and correspondingly, hopefully, there's more opportunity for the size of floor plate that would be required for those uses there. They would also have to be 1,000 feet from a school. And as part of these amendments, we're adding a requirement that 10% of the energy must come from renewable energy or solar panels installed on the site of the micro business. We're also proposing that change to new grow facilities. A lot of communities that are further ahead of the evolution of marijuana law and business facilities have had significant challenges with energy consumption and demand on those. And so we believe that this is a reasonable step towards trying to mitigate some of those factors. Finally, we've made changes to the permitted use table, identifying which of those uses are going to be permitted in which districts and special exception uses. We've added the specific standards or provisions. This is where we've now added the references to the recreational statute. We've added the new uses into the requirements. We've clarified that both microbusiness and retailers are now subject to that 600-foot separation agreement where previously only provisioning centers were. And we specifically have exempted the consumption facility. Previously, there was a blanket prohibition that no consumption could occur at any marijuana facility. Now, with the intention of designated consumption facility to be obviously opposite to that, we want a clear provision to allow for that. And as I referenced previously, we're adding a 10% renewable energy requirement to any grow operation, whether it's as a grower or a micro business, seeking to help to alleviate some of that potential energy demand. Finally, you'll see a lot of changes to the definition section. Again, this is incorporating references to this new third act that's now being proposed to be incorporated into our Unified Development Code. generalizing some of those terms that have a shared definition, be it safety compliance facilities, secure transporters, and the like, and of course adding definitions for the new uses and facility types that are being established. So next up, I'm going to turn it over to Kristen Larkham, who's going to give you an overview of changes to Chapter 96, which is our more generalized permitting ordinance.
Hi, Mayor and Council, Kristen Larkham, Assistant City Attorney. So I am going to talk, and it will be very short, about the permitting ordinance. What we have tried to do is make as few changes as we need to and just incorporate adult use marijuana into the framework we already have for medical marijuana. And as Brett has already gone over, as you can see, there are 4 of the different types in the MMFLA and the MRTMA that have the same name. They essentially have the equivalent function. And so we don't really differentiate between them for the purpose of the permits, the city permits. There is one that's different, but also has the equivalent function, and I think Brett covered that too. Provisioning center, they gave them 2 different names, but functionally they're equivalent. So for purposes of the permit, we have just called it a provisioning center / retailer. And there are these 2 new types of facilities, the designated consumption facility and the micro business. Will be requiring, the ordinance requires permits for both of those also. The current ordinance, it has a 28 provisioning center cap. We're just carrying that over, except changing the name to provisioning center retailer, cap of 28. And at first reading, council amended the ordinance amendment to put a cap on designated consumption facilities and marijuana micro businesses, similarly 28. In terms of, just a minute. So what we've done, and I really think Brett covered most of this already, is we've determined, or the ordinance deems those who have provisioning centers to be provisioning center retailers. And so those who have permits as provisioning centers under the ordinance amendment would be counted in that 28 cap. So I think there's something like 15 permits now. And so those 15 would count towards the 28 cap. I think that pretty much covers it. Like I told you, it was going to be simple.
We just have a couple more slides. Kevin McDonald, Deputy City Attorney. Just wanted to cover for you very briefly the permit application process, which we've spoken of. The current state law that allows these recreational facilities requires that a city to have a competitive process, as is described, when the city puts a numerical limit on the number of permits that are available. As proposed right now, as Kristen Larkham just showed you, as amended by the council, we have permit limits on 3 different areas, the provisioning center retailer, the micro business, and the designated consumption facility. And those 3 particular uses would require this competitive process. And essentially this is such that, and this is just in the state law, that if the state receives more applications than the city is allowing, it really turns to the city to make the decision as to which applications it's supposed to actually issue. And so the language that's in that state law regarding that says that it's really the municipality's duty to choose the applications which are best suited to operate in compliance with the state law. We will be recommending to you, along with the administrator, an administrative process that will be established by resolution. The way that that will work is the city will probably on a quarterly basis open up an acceptance period for a set duration. We haven't decided on what that duration will be each quarter, and then all applications will be scored against the other applications for that quarter, and the city will then issue applications based on those that score highest. And we're really doing this, and it's really to kind of track, and similar to the way that we really process our request for proposals or other applications. It's supposed to be a somewhat objective procedure so that we can very quickly come up with the applications that should rise to the top of the pack, should be scored, and then those folks, when their license are available, will be given the ability to move forward in the process. And so just an outline of the proposed process, and I'm going to be very clear that we have not worked out all of the details. And we're seeing, and I will note that we're seeing similar processes being brought forward even as we speak in other communities around Michigan. But essentially what we're looking at is a points process where the application will be graded against very specific criteria. And here is at least an initial proposal where there'll be some points, maybe 25, granted for past performance experience with the community. That would include things like the applicant history operating the same type or an equivalent type of licensed facility in any community in Michigan, the applicant history operating a licensed marijuana business in any community in Michigan, and then specifically the history of those applicants operating those same types of or equivalent types of facilities in the city of Ann Arbor, and the length of time operating the licensed marijuana businesses, as well as other general relevant management and business experience. Under business plan state compliance, we'd be looking at things like the ownership structure, the chart, the financial structure, and the financing, proof of law pre-qualification, plan to minimize exposure to minors of marketing facilities and the facility itself. Under location, we would of course look at really primarily whether the proposed location is consistent with the city's zoning ordinances, but we'd also want to look at things like geographic equity, making sure that the geographic location of the applicant's proposed facility to other similar proposed facilities in the city, accessibility of the facility to traffic, and other items. Under community interest, that will include points for things like the plan and strategies for community outreach and education, job creation, use of renewable energy, as well as how the facility may respond to specific community needs. But the idea here is that this will be a very specific point system. There'll be points granted for things being achieved, and therefore it will become an objective system and will allow us to meet the state requirements for the permit application process. And so really that is the very quick introduction we wanted to give to you on the UDC, as well as the changes to the city's permit ordinance. And so we will leave it now to council's discussion, and we're happy to answer any questions that you have.
Councilor Love.
Thanks. Thanks, Mr. Mayor. Thank you to staff for conducting this work session tonight and for responding to my many questions about this. As you know, I didn't vote for the two ordinances at first reading last meeting because I did not think that they were ready, or that the staff, city, by that I mean staff and the city council, that we were taking the time necessary to get this right. And I think if anyone reads the responses to the questions that we received, I think you might now share this concern that we're rushing this just so we can be open for business when the state begins taking applications on November 1st. This is a really big deal. Recreational marijuana is obviously coming, and we're setting the regulations that will determine how many facilities there can be, where they can be located, how they can operate. So it's a big deal, and but from the responses, we now know, and I'll just pound through a couple things, we've done zero benchmarking, whether it's what other cities in Michigan may be doing, or whether it's benchmarking a city like Boulder, which we clearly respect and has lived this real-time for 5 years now. Two, we know we need a new competitive process, as was just noted, for allocating permits. We don't have one. I've submitted questions about this. We haven't seen the draft that staff is working on, other than this permit application process, which is, obviously, it's not in any kind of near final form. We've received no specificity about it, and this is the first we've seen in terms of any kind of rollout of a competitive plan. We knew that the state requires this, and I think, obviously we got to approve something in terms of this competitive plan. Correct me if I'm right or wrong, Mr. McDonald, before November 1st. This plan has to be in place, the city's competitive plan?
Are you asking me if it legally needs to be placed?
If,
or-
yeah, or, yes, I am.
I mean, I would suggest that council put it in place by then.
Okay, so whenever you can get that to us,
Unclear.
okay, it would be helpful. Three, we know we don't have a process to allocate permits. We don't know who will decide or whether, like in Boulder, we need an advisory board, and I, for one, believe we do. We know we're tripling the number of facilities from 28 to 84 where retail-type activities, sale or consumption can occur, but we don't have any sense or benchmarking of how many facilities per capita are reasonable or appropriate. I asked about that. No benchmarking's been done. We know that additional policing resources will be required, and that budget amendments for more resources are likely yet this fiscal year. But we don't know how much. Or what the relation is between the number of facilities and the incremental resources required. And we now know our police and fire departments have not been engaged at all. They have not been consulted in developing the regulations we already voted on once, which was, I gotta tell you, that was shocking. So these are just a few examples of why this isn't ready for prime time, and it's amazing to me that we've not taken the time to study this in depth, to study what Boulder has done, and they have lived this. So again, if you look at Boulder's ordinances, as I have done, you see a much more detailed and very specific set of requirements and regulations governing operations, and you see a governance structure in place to monitor and ensure compliance. We have neither. Last man indicated we should adopt a temporary opt-out, temporary, emphasis on temporary. In order to get this right, that failed with several of my colleagues indicating they couldn't support a temporary opt-out of 30 days or so because of the message it would send. Think about that. What terrible message are we actually sending to simply say we're going to take another 30 days or so to study what Boulder and other communities have done to engage our police and fire in the process who've been outside of this process, and to think through the details of the including the process we use to allocate the available permits. All we're saying is that for the sake of our residents, we have a responsibility to get this right, and so we're taking another month or so. We work for the residents, and I'm concerned about the real impacts on them and our community. I'm more concerned about that than perceived messages. And so for those who say, and I'm almost done, no big deal, if there's a problem, we'll make changes later, you know, as I do, that once permits are granted under a set of regs, they cannot be revoked because we decide to change the rules. We live with a set of consequences that comes with that. So when this comes back for second reading, I'll be moving to adopt a temporary opt-out, again, to get this right. And hopefully you'll conclude, again, I just invite anybody to look at the responses to the questions I submitted. It shows you what we haven't done, looked at, who we haven't engaged, on and on. So hopefully you'll conclude we need a bit more time to get this right, but if that fails again, I will have amendments related to specifics of the ordinance, including restrictions on the location of designated consumption facilities and their proximity to each other, on creating an advisory board, similar to what Boulder has adopted, and perhaps others. So I've used my time now, and I have questions, and if there's time, I'll get to those later. Thanks.
Councilmember Rumlowy.
Thank you, Mayor Taylor, and thank you to staff for putting this together. There hasn't been, obviously, as much time as we'd like to discuss this. I'm kind of on my heels right now after listening to my colleague, Councilmember Lum, describe the situation, and maybe I'm a little naive, but I don't have the sky is falling feeling about discussing this and moving forward. This is something that's been talked about in our community, in our state, in our country for a very long time. We have medical centers that have been in the community for almost 10 years. You know, I think I take a different position on this than you do. I think we are doing our due diligence. We are having a work session. We are taking time so that we have the public hearings and the public engagement. We are listening to our residents, our business owners, our community leaders, and the jury's still out. But to slam the door on this discussion before we have this process, I think isn't doing our due process. So I push back on that a little bit. I do have concerns, you know. The competitive process is a concern, but from what I understand, during the first 2 years, and correct me if I'm wrong, I'm often wrong, that the permits are going to be going to the medical provision centers that are currently licensed by the state. Is that correct?
Well, it is correct that you have to be a licensed facility owner to apply. So that would mean, well, at least one meaning of that is that it doesn't clarify that they have to already be in Ann Arbor. So somebody who has a licensed facility in some other location may be able to apply here. But they all have to be licensed, and that's in the state law. So that preference is kind of granted by statute.
Okay. Some of the issues, and again, you know, we can continue to amend our ordinances. So I highly doubt that whatever we pass, if we pass something to opt in, is never going to be touched. It'll continuously be amended and changed as time and understanding evolves. And when you talk about the state, and you talk about laws and regulation, I'm the one to think that perhaps that should be coming from the state legislator and not this body of government necessarily. I don't think we're going to have a patchwork of different laws throughout the state, you know, regulating that. I think that's something that should be brought forth by the folks in Lansing. But my concerns are a few things. First are the caps and the limits, the 28. It just seems that the folks that got in early and are now in business have a monopoly on the industry, and I feel concerned about that. So that has to be discussed. And the social injustices that have gone on for decades, that needs to be addressed. The renewable energy, these growers are huge energy consumers. 10% I feel is woefully inadequate. I feel if locations that are in downtown cannot provide the energy that they consume, then perhaps there needs to be some sort of a trade system. But I would really like to see that number closer to 100%, and it starts much higher than 10%. Another issue is perhaps the odor, the nuisance that these facilities create. And it's not just from the smoking of it, but the actual cultivation. I would like to see something in the ordinances to address the odor that comes from them. And you know, again, back to the social justice issues, I feel like there should be more mandated into programs such as for recovery and affordable housing, and maybe some other health services. But there stands to be a huge amount of money, and that we should take this opportunity to address that now, because that's going to be a lot harder to get in their pockets later. And we might as well get it in now. And so that could, I think, would help solve some of the social injustice issues that I have with it. And I reserve the rest of my time. Thank you.
Councilmember Grand.
Thank you. I'd like to get, and I think some data might help. I know we had this the last time, and it's escaping me. When we put the cap on 28, I think there was a map at some point of given the zoning restrictions, how many places where there actually even could be, given the 600 feet from one another and 1,000 feet from schools, where they even could be located?
There certainly are those restrictions. The 28, my recollection was a combination of the sort of viable locations as well as some consideration of the history of dispensaries and operations in the city, and to some extent an anticipation of market demand in the city. So I think it was for a variety of factors, but I haven't done any updated map for this analysis.
Okay, so maybe that's something we could look at some point would be great, because I'm, not sure. I think we do need to think about this with the caps, and especially if we're capping 28, 28, 28, even with some of them being combined, we may not realistically be able to get much beyond that. So I think that would help inform our conversation. And I don't know if it's you, Mr. Leonard, or Mr. McDonald, can help. I know there was a concern raised by Councilmember Lum about regulations, but my understanding is that much of the compliance happens by the state in terms of once they're given a license, that all of these different facilities would still be inspected, regulated by the state because of the licensing process. So can maybe someone help me understand sort of where that line is in terms of our responsibilities with compliance from the city versus the state responsibilities for compliance from the state?
Sure. Different aspects of compliance is measured by different parties, as you might expect. Typically, the experience of the city has gone through a process where the first step has been land use. That is the location appropriate? Is the zoning appropriate? Sometimes that requires a planning commission action. Sometimes it's as simple as verifying that the zoning district is appropriate for the use anticipated. From that, the petitioner, applicant, or the business owner is typically going to take that information and start a couple of application processes. They go from our office next door to the building department, where they start compliance with building codes. So that is where we are looking at safety, we're looking at the fire code, we're looking at how that physical business is being developed and operated to meet basic health and safety codes as specified by all of our applicable building codes. Then, on a basis, they're going from that, they're going to take that satisfactory completion, which is ultimately us making that determination that they meet all of those building code requirements. They're going to apply to the clerk for a permit under our Chapter 96. They are going to apply to the state for a state license. The state is, I've heard, I'm no expert, but I've heard of a dozen unique inspectors coming through a single provisioning center, looking at unique aspects of that provisioning center from the state for all the rules that have been set up at the state level. At the culmination of that satisfaction, that is the trigger by which then the clerk's office is going to release our local permit that all of that has been satisfied. So it is a combination. We tend to look at the land use, that is the nature of the business, is it appropriately located. Then we look at it from a very technical building code perspective. Does it meet the applicable building codes for that type of use in that space? then the state is doing the monitoring of safety and security and monitoring, and is it adequately inventoried from seed to sale? And that I anticipate is going to continue with the recreational as well, because there's a lot of requirements that even though you might have co-location of some of those facilities, they still have to maintain an independence in the operation. So it's a partnership. I would say most of the inside of building regulation is done by the state, and most of the locational building framework is done by the city.
Okay, thank you, that's helpful. Just an aside that's a little, somewhat related to this, I was looking at our, maybe this is for the attorneys, I was looking at our outdoor smoking ordinance, and it doesn't include marijuana, probably because it was not legal at the time, but something that we might want to look into, because I think it's,
As drafted, we prohibit any outside activities for
Yeah.
any facility.
yeah, but it specifically says, I know like in parks, for example, cigarettes, e-cigarettes. So we have a vaping and smoke and cigar smoking ban, but we don't, to my knowledge, have specific language for marijuana.
I'll leave
in
that to
there.
him, but also
Yeah.
the law does require that it can't occur in a public space.
Sure,
So-
sure, but I don't know, couldn't hurt to, it's a concern that I hear a lot from members of the public.
Councilmember Lum?
Thanks. I just have a follow-on to the inspection Q&A. I did submit a question about that, and so I'd like you to point out where what you just described, you can find it. I assume it's in section 7.6 or 9.
No,
Because you indicated, when I asked about this for the medical marijuana facilities, we conducted no inspections. And that in terms of the inspection process, there's nothing described about the city's process, only that the state will inspect facilities as part of the licensure process. So it's very different, based on that response anyway. My takeaway was that it's nothing like what you just described, and I can't find that in the ordinance that you just described, because for liquor permits, the process you described is what we utilize for liquor permits, but I don't see that anywhere laid out. And in fact, to the contrary, it's indicating in the staff's response, there will be a state inspection as part of the licensing process, nothing more, nothing less. So we haven't done any inspections for the medical marijuana facility, according to the staff response.
to be clear, we don't do any additional inspections of marijuana facilities than we would for any other business. So for any business, we make sure it meets.
For liquor permits, we do.
From a zoning and building department, we inspect the building based on the proposed use. Is it a mercantile use? Is it a industrial use? Is it an assembly use? And so based on that use proposed, what we have to do is we measure to make sure that that building is safe and it's constructed and meets the requirements of that. The culmination of that is the certificate of occupancy. Whether we're issuing a certificate of occupancy for a coffee shop or for a medical marijuana provisioning center, we are making that determination that it meets both our land use and our building code and fire code requirements with that certificate of occupancy. Then there's a whole host of other standards under both the medical marijuana facilities and the recreation that are going to be required by the state that tend to be more focused on operational aspects of the business, which are outside of those building codes, which we have the responsibility to enforce. So I apologize, I wasn't trying to convey that we don't inspect them. We inspect any use pursuant to the zoning and to the building code to make sure that it's safe. We don't do anything specific or additional for marijuana facilities than we would any other business.
And I just want to put Councilman Graham, and this was asked of you by, or not asked, just Councilman Graham Molly said, why just 10%? Maybe you did ask that question in terms of the energy offset.
Yeah.
And as you know, I sent you the Boulder code and ordinance, and they're required, their cultivation facilities at least, this is non-thanks. Their cultivation facilities are required in Boulder to offset 100% of the electricity consumption. So again, I don't know if that was a question, but anyway, to the question that,
Well, I can just tell you the evolution of that. We did look at higher percentages. We consulted with city sustainability staff on what was a reasonable, attainable threshold based on our typical solar exposure and sort of square footage. And based on that conversation, it's for sure, it's an inexact it's hard to set a standard for everything, but generally speaking, giving our solar exposure and other factors, we estimated that 10% would be a reasonable threshold to achieve, presuming sort of coverage of the corresponding square footage of that space here in Michigan. I think Boulder does provide some other ways that you can achieve that through maybe
Right. I
purchasing.
think I sent you a presentation on, yeah.
Yeah, and that gets into what frankly, my goal was through the development code requirements is to try to find a sort of reasonable on that site standard without starting to wade into the complications of public service commission requirements about our limitations of directing people how they have to get their power. So other communities have had a drastic impact, energy impact from these grow facilities, and this was an intent to acknowledge that and at least put a stake in the ground in what we thought was a reasonable and defensible manner on a site-by-site basis.
Yeah, so again, in Boulder, they need to have a, quote, verified subscription to a community solar garden to offset 100% of their use. And, perhaps, you can come back with this, some suggestions for, maybe there are ways to contribute to offsets, like we do with, Affordable Housing Trust Fund contributions, if they can't do it on site. Because I know, for example, and there are certainly opportunities there. We're going to be doing this solar garden field, whatever you want to call it, array, potentially at the municipal airport. And I understand that's we're going to have to repay DTE $44 million for that. We don't have a financial plan for that I'm aware of. Nothing's been shared. So there are significant opportunities for these lucrative businesses to help offset their energy consumption by making perhaps financial contributions to that. Since we need to come up with some financial plans for
Yeah,
that
happy to-
array at least, so
I'm happy to look at
thanks.
other options.
Mr. McDonald?
I just wanted to quickly respond, I think, to questions from both Councilmember Grand and Councilmember Lum. And I just want to make it clear that the city doesn't usually adopt ordinances or ordinances that sort of repeat requirements that are in the state law. And so similarly, I would just like to say, in terms of licensing, we certainly within our Chapter 96 licensing allow for city inspections. I'm not saying city inspections have taken place, but that is allowed for in the licensing provision. It was never our intention to replace and/or it's really just a supplement. Well, we're certainly not replacing the very extensive due diligence and inspections that the state is doing regarding their requirements. Similarly, I just wanted to say to Councilmember Grand, you mentioned the smoking ordinance, but I wanted to make sure that it's clear there's all kinds of provisions of the state law where things are being allowed and not allowed. We don't necessarily pull those into our codes if it's clear. Under the state law, smoking marijuana in public is not being made legal here, so it's not something that we would normally have a prohibition on in our local ordinance that simply repeats that which the state has already said is not legal.
Councilor Hayner?
Yeah, thank you. I guess it's just sort of Q&A for whoever wants to answer this. So follow up with what you just said, Mr. McDonald. So if the state law prohibits smoking marijuana in public, and we all know how well that works if you've been to like a music festival or anything, like on Hart Plaza, what authority would the local municipality, RPD, have to enforce that state law unless we had it on our own books? Would they have the authority to enforce that? Should they choose to? Complaint driven, or how would that work?
If we don't have an ordinance, then the police would enforce that under state law. That simple. We could have an ordinance, and then they would proceed under city law, so.
Okay. So while I have you up here, so I have a couple questions based on their presentation. So when we talked about creating these new rules, we're talking about striking the word medical and calling it simply like marijuana provisioning or marijuana sales.
Yes.
But it's my understanding that medical will be allowed to continue. Cardholders will be able to continue to purchase medical marijuana. But there's a state tax structure in place that's different for these two. And so how are we gonna define what is it up to the retailer to define what is to keep the records on what is a medical sale versus what is a recreational sale? And is it, because the tax structure is different in what comes back to the communities, do we have any concerns about what type of sales are going on as to what's, what's happening, what's getting looped back to the city through the state law?
Well, I think that's going to be administered by the state, and there has to be, they're going to be separate businesses. They may be in the same building, but they're separate. And that's by administrative rules require that there be a separation between the two. So
So they're keeping separate books, even though it's a cash operation and so on? They're two separate sets of books?
that's my guess.
I believe it's a separate set of books, but it's certainly a separate inventory, and everything has to be separate if those are co-located businesses.
Okay.
The state has, the state has pretty extensive rules regarding the co-location of these businesses, and they're not really allowing things to be combined in a traditional manner. Some of the uses even require separate entrances and exits, such as if you have a designated consumption facility and a retailer in the same location. Separate entrances and exits, separate inventory, I believe separate books and records, but it's really kind of complete separation.
Okay, so, when Councilmember Lum spoke of this medical marijuana or marijuana review board, I know that I sit on the liquor license review board with her. And so there's a case where we have local rules and some local authority. We've granted ourselves some local authority, even though it's a state licensing process. And, we do that we have a building review board for the state licensed building activities. So is there any reason we wouldn't have this for overseeing this marijuana licensing, even though it's a state license? Why wouldn't we give ourselves some authority over that? I know with liquor license, if we have a situation, the fire marshal goes in there, or the police have a certain number of calls to a facility, we have an opportunity to interject with the state's license and say, this is not working out in our community. These people are in constant violation of this license. We want to pull their license. So is that authority not given to us under these state laws?
I would say right now, it is not. There is not a process like that under the state law. We can always make a complaint, and if there is a problem with a particular business, I think we would.
Yeah, and part of the purpose of the city having a permit section is the city has the ability within that permit section, if somebody is in violation within our ordinance, to revoke the permit. And that would be communicated to the state, where we would indicate that they no longer have the ability to operate here.
Well, it seems like the board would be a good place for that to function. I mean, at the very least, we could go count their solar panels, I mean, it just seems like it would be worthwhile to have a board oversee these permits and not lay that on staff. I mean, we don't seem to have a problem with liquor license, and it has all kinds of other benefits to the business community and to the business owners. I mean, are liquor licenses capped here in the city in any meaningful way?
It's according to state law. I don't know. My understanding is there are quotas, there's on some types.
I mean, I know the DDA, I know what their function
Yeah.
is, and so I know that we've approved some of those licenses. I just wonder if it's analogous and if it's something to consider when we look at the amounts that are held. Let's see what else I have here. I'm going to pass, and I'm sure more will come up if that's okay. Thank you.
Councilmember Nelson.
Councilmember Hayner mostly asked the question that I had, but some of the response that you got actually triggered some more questions for me. Mr. McDonald, you said that even without a board, we could communicate to the state that an operator was in violation and that we wanted them to remove their state law. I mean,
Well, part of the purpose of us having a local permitting process is we're granting permits, and there's a section in the ordinance, and it's been in the ordinance even from when the medical marijuana facilities were present, that allows, excuse me, the city to revoke permits. And one of the things that they have to do is continue to comply with the state law. And so that is a tool that is available to the city. And I wasn't really trying to speak towards whether that was a board implementing that tool or someone else. I was just trying to speak to the tool itself.
Yeah, because I guess, so I don't sit on the liquor board, but I was curious, just Googling in the last 15 minutes, trying to find situations where a liquor license had been revoked. And I guess I'm looking at the standards that we're applying, and, I mean, apart from something really cut and dry, like failing to pay taxes or something in order to remain in compliance, is there any circumstance under this ordinance as proposed where, for instance, a facility just had created a total nuisance in a neighborhood, and there were, like Councilmember Hayner suggested, there were lots of police calls or something without
to minors.
Yeah, something like that, where, I mean, I guess that strikes me as the opportunity for a review board of people to consider something that's not just a piece of paper saying they owe $3,000 on taxes that they didn't pay. Sort of more broader circumstances that need to be judged by people rather than a calculator. I mean, do you follow what I'm saying? I guess I'm asking, so I'm looking at these standards. So past performance experience with the community, business plan, state compliance, these 25 points for each of these 4 categories. Would that standard apply for a renewal of a permit, or would the permit renew sort of as a matter of course if you had maintained your state license?
Are you referring to our competitive process for issuance of a permit?
I'm actually asking about renewal of a permit. I mean, this is I'm sort of piggybacking off of Councilmember Hayner's question in terms of the power that our liquor license board has when a liquor license isn't working out. That's my question.
I think that permit application process, if that's the competitive process that we've set up, then we would look to apply that as well.
In the renewal process?
In the renewal process,
Okay.
yes. Excuse me.
Okay, thank you.
Councilmember Amlawi.
Thanks for the second opportunity to speak. I just wanted to ask Brett real quick, and I know you're not the fire marshal, but the fire department has done a pretty vigorous job as of late inspecting buildings throughout our city. Is that correct? And those are done yearly, annually?
The fire department enforces the fire safety code, so sometimes that's regular inspections. It's also review of new developments.
Okay. All right, I just wanted to make sure that that was a very enforceable inspection. And then, that's all I really have, I'm sorry. Wish I had more, but I do sit on the liquor license review board as well. And it's a fun board to be on. It's not a time suck, but you learn quick that our powers are very limited as a city, and most of that lies in Lansing. So when we go ahead with our competitive process, we're going to really need, if we go forward with it, more teeth in that review process, because currently it's very hard to revoke the city a liquor license. There could be a lot of complaints and very little can get done. But I do strongly support modeling a review board, and perhaps the same people, to be honest with you, because it's such a light load. It could use, if you use the calendar correct, it can do both, in my opinion. And it's a very good body, because there you have the building department, the fire, the police, the city, the treasurer. Everybody is listening and reviewing these applications, and each department gets to review it, come to the table and say, you know what, they didn't pass their building inspection. They didn't pay their taxes. They've had 100 calls in the last year. And then as a body, we can make recommendations when all these different facets of our city government come together to review the license and the application. So I strongly recommend that, and I really do believe the people that sit on the license for the liquor license can do this task. So I just wanted to comment on that, and I won't take up any more time. Thank you.
Councilmember Hayner.
Yeah, thank you. So, and a thing I'd like to emphasize is that this Liquor License Review Board, it's not like a punitive board or anything. It's like we come in, we talk to everybody, we find out what's going on with the business, why is there a problem with the business, why do they have complaints in the community and so on, and then we send the appropriate people to discuss it with the owner. And we want to solve those problems. We want these businesses to be in business and have a strong business community here in town. So it's not a punitive aspect. And I think it is entirely appropriate, and I think that it, to have something like that. And I think it will give us an opportunity to create a place for outreach with this new type of business that we're allowing to, potentially flourish here in the city. It seems entirely appropriate to have one. And so I guess maybe Councilmember Lum and I can get some language together or Ali, if you'd like, get some language together for the next meeting to form one outside of this process, because it's also a good way to, it's entirely appropriate that it sits in that board with the same type of makeup, because, the clerk is the key to that, and the clerk is in charge of permits, and she's in charge of the Liquor License Review Board.
I've got a couple of questions based upon presentation. I guess just cycling back from the last conversation, the application criteria have been articulated, that is to say, these 4 25-point nodes. Do we have established criteria for renewals? Because it seems to me that these criteria wouldn't really make much sense for renewals. The location, that's not going to shift.
Yeah, no,
way
as
example.
I really said, we wanted to kind of show you that kind of as an outline. And I was
Understood,
trying
and
to be
for
very
applications,
clear
I
that
think
we
that
had
makes
not
sense.
developed the full point system.
Understood,
So
both.
similar for renewals, that would have to be taken into account.
Perfect. So the renewal criteria will ultimately be separate from the application criteria.
Separate or included within, so yes.
Sure.
Where is that?
And as I gather, I guess a couple of other points, there's been some reference to funding and, the opportunity for municipal revenue and the like from this line of new businesses. I'd be grateful if someone on staff could articulate for folks on council and for the community what taxes and fees and the like come to the municipal organization.
So the licensing
structure.
fees are $5,000 per license, and that's the maximum that's allowed under the state statute right now. We also get a percentage of the taxes on sales of adult use. Don't know that it's possible to forecast what that'll be right now. So as a matter of general policy, matter of practice, we don't count revenues until we have a year's experience, so we don't know what that'll be. I think there are some costs we're going to have to consider based on informal conversations with folks in Colorado and personally with people in Eugene, Oregon, that will address some additional police staffing, some equipment that, again, some of this is going to have to be a mid-year adjustment, as Councilmember Lum talked about. Chief Cox and I will continue to work on that with City Attorney's Office, but there'll have to be some adjustments as we go through it. Cities that have gone through this have experienced some increases in armed robbery since it is a cash business. There are some additional costs that deal with emergency room visits and those kind of related medical costs. I don't think most of that is related to the city. We do have inspection fees for the fire department to inspect commercial establishments. There may be some requirement for additional fire inspectors as well. But as much as we'd like to have certainty before we get started, I don't think that that's entirely possible right now. And there will be a year or two of additional costs until we probably see the sales tax revenues come back to the city. And I don't know that you can say right now whether it's going to cover the additional cost or not.
What is the sales tax percentage, if we don't know the absolute amount?
Jeff knows.
Yes.
There's an excise tax that's going to be 10% of the sales price of marijuana.
It's my understanding that the cities, the municipalities that are allowing this operation get 15% of the 10% of the excise tax. And so that means for $1 million in sales, we get $15,000.
It's based upon the number of facilities, though, that.
Yeah, there's some
that-
other
that
variable in
exist.
there.
And so I think the 15%, I believe, is correct for the municipality, but it's based upon the total collection and the total number of facilities that exist. So we don't know what's going on around the state. It's hard to predict right now.
With respect to odor, which I've heard here at the table and I've also heard elsewhere, am I correct that there is, from staff's perspective, there's no reference to odor in the ordinance because odor is one of a classic nuisance category that's dealt with through other mechanisms?
Odor is referenced in the ordinance. You can't have any impact of odor, noise, some other nuisances specifically relative to marijuana facilities beyond the premises.
Thank you. So my apologies. So odor is in the document as it currently is. Excellent. And with respect to the proliferation of businesses, I understand that we have limited a number of the businesses at 28, but those are different categories of businesses. Without regard to businesses that well, let me put it another way. If you, what do we anticipate the maximum number of locations at which marijuana-related businesses exist?
I don't have that map. Based on the experience of medical, we had a cap of 28 provisioning centers. From a land use perspective, 26 of them have been approved so far. We were a little over a year into that ordinance, and about half of those have actually gone through the entire clerk's permitting process and state process to receive all of the required licenses and permits. So some combination would be of our location restrictions, obviously market demand, which your guess is probably as good as mine. Based on that experience with medical, my gut is that we would probably get closer to 28 retail/provisioning centers. I would probably be surprised if we got to 28 designated consumption facilities and micro businesses, but.
And when you
that's
say
just-
that if we got to 28, do you mean we got to 28 that were co-located at these sites or additional locations at which these things occurred? Because for my part, and my suspicion is that it doesn't really make much difference to me from a proliferation perspective if there are two businesses at the same site.
Yeah.
That's one business from a perception perspective.
I think with the change to allow co-location of consumption facilities and provisioning centers/retailers, they will, I think it's probably safe to assume many of those will end up in those shared facilities. I think the reason for that is some of the limitations, frankly, on the business model created by some of the restrictions from the state. It's going to be somewhat more restricted than a bar or restaurant, for example. So I think that is possible that many of the provisioning centers will incorporate consumption facilities. However, not all of them might have the physical space to be able to meet the state requirements of separate entrances and the like. So again, it's just my instinct, but my guess is that we're more likely to reach the cap with provisioning and retailers than the other uses.
Thank you. Councilmember, I think, who was next? Lum?
Well, I just have more questions. If that's
Anyone
okay.
who hasn't yet spoken? Councilmember Griswold.
I want to put this discussion tonight in perspective. And one of the things that happened, according to the Associated Press on September 19th, is that the U.S. government awarded $3 million, and the headline says, to fill gaps in medical marijuana research. And one of my reasons for being an aggressive supporter of marijuana use is to address the opioid addiction crisis that we have. And it's not just medical marijuana. And I've had family members who have been negatively impacted and who have lost their lives. And it's because when you use a painkiller such as opioids and then you become addicted, your doctor is not going to give you any more. And in fact, heroin is cheaper on the black market than opioids are. And if we can provide an alternative such as marijuana, and again, I'm talking more about recreational marijuana than medical marijuana, then possibly we can impact this crisis that we have with opioid use. And I've talked about it a lot, and I guess given that the U.S. government is now funding that research, it's becoming more mainstream at least. Another issue is that we have an extra week. Usually we meet every 2 weeks, but we have an extra week to work on this. And sometimes I'm allegedly critical of staff or the lack of a staff person. In this case, I think that our staff working with council members and whoever is needed, that we can at least be ready when we next meet in 2 more weeks. And one thing that I'd like to bring up, and I know that this won't be addressed in the near future, but there are bills being introduced for the expungement of criminal records for people who sold marijuana in previous decades. And so we need to be aware of that because there are people who are in prison for doing exactly what we're going to allow other people, mostly wealthy white people, to do in the near future. And so I would hope that a percentage of the profits could somehow be used for rehabilitation of these people that are coming out of prison for doing exactly what other people are being rewarded for now. So, thanks.
I've got Lum then Nelson.
Thanks, just more questions. You can hang at the podium if you don't mind, Mr. Leonard. Back to the inspections.
My apologies for any confusion.
So on that, again, my understanding, based on the response, was that we'd be deferring to the state. So that sounds like that was an inaccurate interpretation. So in following up, if you could provide after this meeting, lay out the inspection protocol, the frequency, and who will be doing it in detail, that would be appreciated.
And what it covers, I presume.
Okay?
Yeah.
Because then I need to know if, the proposed ordinances, need to be amended in any way. The application permit scoring process, are we going to get that likely the first meeting in October or the second? Or will that be presented, will the permit fee resolution be presented at the same time that we, ultimately approve the ordinances? Mr. McDonald.
At this time, I'm not sure when you're going to get it, but we're going to try to get it to you as quickly as possible.
So,
Go ahead.
next meeting, that first meeting in October, second meeting, before?
It will
November
be
1st?
before the second meeting in October. I'm not sure it's going to be before
Okay.
the first meeting.
It'll be on or before the second meeting in October.
Yes.
Okay. I had, one of the concerns I've asked about was not having any restriction on the concentration of designated consumption facilities like we have on provisioning centers, retailers, and micro businesses. And the response was that staff didn't expect there to be as many consumption facilities as sales outlets. And what's the basis of that expectation?
Business model that there's no public consumption. It is legal to ingest and use marijuana in your private home. That I think that there are probably segments of the market who are really going to look for a public consumption facility. For example, if they are a renter and smoking is prohibited in their, as part of their lease, they might want to seek those places. However, I think that there will be some large segment of the population who is going to want to consume marijuana under state law at home. And therefore, I just think that my estimate, and this is me swinging at the market, is that of the market for recreational marijuana, not everybody who wants to use it and buy it is going to want to ingest it and use it in consumption facilities.
Just like consuming alcohol in that sense, then, maybe. Do you see any harm or downside in having a 600-foot restriction on the proximity to another consumption facility like we do for provisioning centers / retailers and micro businesses? In case that expectation, your expectation is wrong or a low number?
My initial thought is no. I think that consumption facilities are a similar community experience and user experience as retailers. That standard has been applied to retailers. So no, I don't think it would be a significant challenge in some ways that would eliminate the opportunity for consumption facilities in the city.
So you see no harm or downside?
I don't see it sort of
Okay.
effectively eliminating them in our community.
Okay. Can I ask about parking question?
Sure.
I asked why we would not require parking at a designated consumption facility, but do so for a provisioning center or micro businesses. And the response was that staff and the planning commission did not think having a minimum parking requirement for cars was important. The ordinance does require a minimum number of bike spaces, and that's a different question, obviously. But in terms of vehicle parking, why do we require minimums for bars? Again, I'm looking at equity there, but not for designated marijuana consumption facilities.
I think it's a great question. I think we should look at bars.
I'm sorry?
I think we should look at bars as well.
So you're saying revisit, that
So
we
the planning
require
commission has
minimums, that we require minimums for bars, relook at that, you're saying?
So separate from this, planning commission has identified looking at parking standards as potential ordinance changes. There's a lot of evolving thought about parking requirements in communities, specifically that when communities start setting minimum parking standards generally, we are adding to the cost of development, and we are sort of forever.
Right,
Yeah.
sorry.
So-
If you're going to
so-
go down that path, I know that argument,
So
but I
in
will just
this,
say.
in this circumstance, I agree. I think that there is a similarity and an equity to look at
Yeah.
bars and restaurant as there are consumption facilities. In this case, as a new use, both staff and planning commission thought that this was appropriate as the primary use of this facility, unlike bars and restaurants, which might be more of a combination of food and drink, was consumption of marijuana. And while we're not prohibiting parking, for the city to require that a certain number of vehicular spaces be associated with that use, it just wasn't elevated to a priority, so that's why we set it at a maximum
Okay,
instead.
honestly, I'm a little surprised at your response, because I will just say, as a member, I've been a member of the liquor, advisory committee for quite a few years now, and I appreciate that council members Ramlawi and Hayner and Nelson, who's not on the liquor advisory commission, appreciate that, and I resent to everyone, and I sent to you last week, the city attorney, Boulder City Attorney memo about treating these types of businesses similarly. And when we do these liquor license reviews, it is a great, that process was set up before I arrived at council, and it enables the city to recoup taxes, unpaid liquor license fees, make the businesses compliant with the fire code. The building department takes a look, Treasury, obviously, the city attorney's office, and it's a way to help businesses and make them compliant. And it's a good thing. And the Boulder City Council determined that there were inequity issues, and so that's one of the things their marijuana advisory board takes a look at and oversees and advises on not only policy, but on this kind of, these regulatory requirements. And so, and they really wanted their recreational marijuana penalties, fees, requirements to mirror those that they established for liquor licensed businesses. So, last question. As you know, I submitted, so I was surprised about the parking, difference. So I submitted questions related to the Boulder ordinances, as you know. And then I guess those answers will be forthcoming. For now, two in particular, I wouldn't mind a response to. One, Boulder includes childcare centers and drug addiction facilities in their definition of schools in their 1,000-foot rule. We say that childcare facilities aren't relevant because it's young children who are, quote, not independently at risk, end quote. So I'm wondering if you or Mr. McDonald could explain what that means and why you think Boulder may include childcare facilities.
I can't speak to why they include childcare facilities, but as with a lot of discussion this evening, the language in our medical marijuana separation provisions, I believe, came out of the conventions applied by the state as it relates to liquor licenses as well. And so that's where we started in sort of pulling that language forward. As you recall, we did have a conversation about potentially making those changes. That wasn't realized. I think that
Right, it was based on the LA ordinance.
some of those standards, as you'll recall, those, I think they were very measurable, identifiable facilities. There was other language in the proposed change that I think was probably more difficult to categorize and determine. But I don't know why Boulder's language came from, but we started from how exactly liquor licenses are considered in the context of schools.
Councilor Nelson Hainer-Grand, and then perhaps we call it a day.
Well, I had two questions
I'm
on
sorry, I
Boulder,
thought you
but
said that
sorry,
was
can
your
I just
last
quick one, a fee question? Because, I copied you on all the other questions. It was one fee question, since you're standing here. So Boulder charges charges fees beyond permit fees, and related to cleanup and inspection of marijuana facilities. And do we have any plans to adopt fees beyond permit fees for additional costs that the city may incur?
We
So
do have
this-
fire inspection fees, so that covers the cost of the fire department.
Yeah, I was,
Where is that in the proposed ordinance? It's laid out in Boulder's, but I don't see it in ours.
Well, it's a commercial establishment. We inspect commercial establishments. So
But
I don't know
it's
that it
not
needs a-
related, it's not laid out in this ordinance.
so just a couple provisions in regards to that. No, the medical marijuana UDC and as it relates to the Chapter 96, any methods that are available to the city for enforcement of any codes would apply to marijuana uses as any other use in the city. So in the case of fire code inspection, any provisions for fees for any routine inspections of the facility, or if it's a fire suppression certification, that would be governed in the fire code and what those inspection fees are established. Likewise, when we're issuing, of course, any building permits or certificate of occupancy, those are going to be introduced in that. As it relates to the actual petition fee, both laws actually create some caps by which we can't charge any more for the application fee at the municipal level. I think it's $5,000 in both acts, if I recall. So I guess the only piece that I
That was a
don't have.
licensing fee. That was the licensing fee.
Correct.
Right.
So, and that's going to be on top of any normal conducting business and development fees, separate from that. So for example, the building permit fee is not included in that $5,000. That's going to be an additional building
that's what I was
permit
yeah,
fee that we
right.
put
That's what
on,
I'm
that we
asking
charge to any
about.
building permit.
So they won't get a license until they have a certificate of occupancy. They can't get a certificate of occupancy unless their plans are reviewed and construction's inspected.
Correct.
Those are all covered by the building code.
Yes, not specifically by the marijuana ordinance.
Councilmember Nelson.
I've been scribbling on my pad all these numbers that are flying around and trying to figure out how they add up to make the biggest numbers. Somebody needs to explain to me. So, in our response to questions, there's, well, actually, let me back up. A couple of people have communicated with council and expressed the idea that there are these permits that have been issued to speculators, or people have gotten permits and they're not making use of them, and with 26 out and the limit of 28, there's sort of this, this chase after a scarcity, right? And I've been looking at so I'm trying to figure out how we add up to 26. In our response to questions, there are 26 provisioning centers that have gotten a special exception use.
Correct.
But then a few lines above, it says there are 15 permits for provisioning centers.
Yeah, so,
Help me understand that.
sure. 26 have received that land use or special exception use under the zoning requirements. That is, the city has made the determination that their proposed use is appropriate in their location, subject to conditions or standards. They have to take that, as well as compliance with the building and fire code, to apply then to the clerk's office under Chapter 96. All the previous zoning is under Chapter 55 to say, we would like to receive a permit from the city to operate a provisioning center at this location. They pay a $5,000 fee to the clerk's office after they have already demonstrated that they have the zoning and the building certificate of occupancy. The clerk's office starts processing that application. Then after somewhere between making that application and finalizing and approving that application, the clerk's office is waiting for an extensive inspection and verification process to happen at the state level, at which point they receive their license from the state, which is the final benchmark then for the clerk's office to issue the local permit under Chapter 96. That permit's good for a year. They have to come back on an annual basis and reapply. At that point, my understanding is the clerk's office is going to distribute that request to all the various city departments, fire, building, zoning, police, soliciting any feedback about any positive or negative community experiences that has associated with the operation of that over the past year, and then take that into account with a determination about whether or not to issue a renewal of that. I hope I'm on the right frame with that.
The clerk is taking that information
Correct.
right now,
Yep.
like under the current ordinance?
Yep, very similar to liquor license renewals.
If I could add, though, just to get back to the question, the council has limited the number of permits, not the number of SEUs that are given. And in order to get through that process, without assurance that you're going to get a permit, you still have to get the use approved through the planning commission. So we will, whether it's the intent or not, wind up with more approved uses than we have permits.
I would look at it, I guess I would respond to it differently.
it.
That sense of prospecting on these is a function of two things. When the city created a cap on the number of provisioning centers and designated that these uses have to be special exception use permits, that really created that circumstance, because by law and judicial precedent, special exception uses run with the land. They don't run with the tenant. And so what has happened in some circumstances is the tenant has worked with the landlord, sought approval to apply for a special exception use, received that, and then something happened in that relationship where now the property under law has the benefit of that permit, not necessarily the tenant. And even though in some circumstances, to be clear, the tenant kind of did the heavy lifting to go through that process, maybe pay for the design application, et cetera. So that's probably what you're hearing about in those circumstances potentially.
But when the changes that we're talking about adopting, it's not every location is going to be a special exception use anymore, is it?
All provisioning centers and retailers are, micro businesses are, some of the other uses, depending on the zoning district where they're located, are either permitted or a special exception use.
Okay. All right, so
they
okay.
don't all
This
require
answers
that.
my question, because I was just trying to make sense of this perception that we,
The
you know,
20
that
yeah, the
that people are
26
fighting over two remaining opportunities to have, okay, I
Well,
get it.
the-
Thanks.
Yeah, But to be clear, we've sort of, as a city, we've now, based on our decision, mapped out 26 physical locations where provisioning centers may be located. That's under conditions. Those have to be realized within a certain time frame. They have to receive a city permit and a state license. But that could happen by tenant A or a substitute tenant, as long as it happens within that time frame. In the circumstance where those conditions are not met within a required time frame, essentially that's going to open up the opportunity maybe for a new location.
I actually have a follow-up question. So if it's just a matter of defining the land use as like a potential use, we could theoretically have a special exception use for 1,000 property. Well, I mean, we wouldn't, but if the limit is on the permits, then it really, the special exception use, if no one's following through with getting a permit, does that make sense? I mean, it doesn't really matter how many pieces of land we allow the use at, if it's limited by the number of permits. That number 26 is not as meaningful as the number 15 of the actual permits.
I mean, it's an interesting question. Under the Medical Facilities Act, there wasn't the same requirement of a competitive process. It was more, how did the city believe that it was equitable and fair to determine where those 28 permits might, in what order might they be considered? So I think your question is a good one. You could approach it that way. Thus far, we've been very careful from a staff perspective not to set up the expectation of receiving a special exception permit without the likelihood of a
Likelihood of, yeah.
permit ever being granted. It is conceivable that we could shift that expectation and rely on the competitive process. But to be clear, we're going in the opposite direction with these proposed changes. It specifically says we will not issue more land use permits than will be permitted under Chapter 96.
Oh, so as a policy, we're not
It's
going,
proposed in the code at this point as part of the amendments.
oh, okay, thank you. That's helpful.
Councilmember Hayner.
Yeah, thank you. So these special exception use permits, so they apply to the micro businesses
And yes.
and the consumption centers, no? We're going to change that. That was an error, right?
No, designated consumption facilities were indicated as special exception use. They should be listed in the special exception use section.
Oh, okay.
But they were listed in the permitted use table correctly.
All right.
And micro businesses, let me just double check that.
So the use of those are defined by state law, right? So that type of business is defined by state law. So a consumption center has to have certain properties, a micro business has certain properties, 150 plants. That's new micro, I guess. So I just had a couple questions about the state law as it regards to these two types of facilities. Is there in a consumption center, you can't purchase, but you could have a co-located, separate access, separate bookkeeping, everything. You go to the one place, you go next door to consume. Is there a minimum or a maximum set as to what you can bring in there, how many people can be in there, how many people come in together, that kind of thing? Is that defined in the state law? Like if I reread the state laws, I'll know these answers? I mean, the volumes that can be sold, is it the same for the micro businesses or for the retail outlets? Is there a minimum or a maximum purchase that has to be made? I'm just curious.
If you go back to the law, there's a maximum amount that you can possess.
Right.
As an individual recreationally, so.
So that's
there
the
are
maximum
limits.
for walking out of a retail.
It's the maximum you could have on your person.
And walking into a consumption center, same thing. It's a maximum.
If you exceeded that level, you would be in violation of the act by having too
Okay.
much.
So, okay, so my next, I'll try and be brief. So we talk about these caps, and it's my understanding that if we had no caps, then there'd be no need for this equitable permit application process. Is that correct?
That's correct.
So we're kind of creating work for ourselves and a whole process by setting these caps in place. Okay, so here, just one last comment. So I know that businesses, no business likes to operate in a regulatory environment that's like a constantly moving target. You don't want to set up something, make an investment, go through all these hoops, to find out that later on, council body's going to make it more or less permissive for you to operate under these rules. And so I know that every day that rec marijuana isn't being sold in these environments is money lost to these people who have invested in this. But at the same time, it seems like I'm fully supportive of letting these things happen in the proper way. And I hate the idea of giving businesses a moving target and say, we're going to come back and be more or less permissive later on, we're not sure yet, especially if we're going to be the target of lawsuits moving forward, because we are adopting these, unlike 840, or maybe it might be 1,000 cities by the time November 1st rolls around. And so I'm sorely tempted to support a temporary and fixed point in time opt-out until we get it together. But I hope that the calendar of September giving us this extra week in between will do that for us. I hope that we can come together on this and get all the things that we feel we need to be protective of the community. And if you read the preamble to Boulder's law, there were two things in there that we don't talk about that I think are interesting. And one is they recognize that this is still all unlawful under federal law. And I wonder if we shouldn't make that same kind of statement, that we recognize that to protect ourselves in the future. And they also recognize that their law is written to be protective of the community at large, not to it's for the community's benefit, not for these businesses' benefit. And I think that's something else I would like to see in our preambles. Thank you.
I got Grand, then Bannister, then perhaps, I think we'll probably run up to our time. Councilor Grand.
Thank you. Mr. Leonard, and I think Councilmember Ackerman answered this question for me, but I think it's something I just want to state publicly. So if you have a special exception use and you don't get a permit within 3 years, that special exception use disappears?
Correct.
So that is a way that we can provide an opening for additional permits if that's not realized. Okay, so I think that maybe helps structure the numbers conversation. Just a comment more than anything. I just wanted to speak to these parking maximums. I think it could be reasonable to assume that at a consumption center that there would be employees that you might want to provide parking for. Otherwise, those that are consuming, I'm not really keen to be providing parking for those folks, even with, I know, the education and watchfulness of that will occur in these consumption centers about making sure that folks aren't over-consuming, particularly if this is their first time in such a facility. But and I would be all in favor of us moving that way with bars as well.
Councilmember Bannister.
I had some follow-on questions about this 600 feet and the caps. If we have a location that has their SCU and they've gone dormant, but their 3 years isn't up, so they're holding that 600 feet, but there's another guy, another business just 100 feet away, I could see how they could possibly get out of luck if another business that's 600 feet away from the first business, but an interloper, so to speak, but not away from the second business, he could be stuck in a bad situation where he'd be discriminated against, so to speak. How because of this 600 feet, or maybe it's because of the caps, is there a way to handle that?
So that's how we face that exact problem in circumstance with medical marijuana provisioning centers, and that's where I was referencing it. It wasn't dictated by the state law, but rather our legislative conscience on what was a fair and equitable way to deal with that circumstance. And the way we did that is we set up an opening time, at which point we would start accepting applications, and we considered them in order. And we were very deliberate, where we would go through applications to make sure we had the materials, and then we would start review with them. And if that circumstance presented itself, we would hold an application in sort of queue until a resolution occurred on another determinative application. So I think the opportunity exists as it relates to recreational to probably refine some of that through a competitive scoring, the location category, for example, as Attorney McDonald indicated. But in short, we had to deal with that exact circumstances, and that's how we did it with medical. As indicated, we would probably provide a more specific scoring competitive process for future applications for retail. And to be clear, with the inclusion of a cap, the competitive requirement is specifically for recreational uses, not for medical facilities.
Okay. And another problem along sort of in that same way that could be a problem later. So if the state expunges records of people who were previously in prison for selling marijuana, and yet we've already capped, and Ann Arbor's already in business and we're capped and we're filled up, those people that are now expunged and eligible that we're trying to not be discriminate against, that, I guess, would be addressed with an ordinance change in the future?
Again, I'd put it in two categories. One, you could address it in the competitive scoring, find the ways that you would want to provide a more competitive result for applications that were coming out of that circumstance. And then I would say the state, this is an imperfect answer for what the decisions we make, but the state is also very actively trying to provide additional resources to communities across the state that have been more significantly impacted by those kind of circumstances. So they're actually actively putting up training sessions to help cultivate new businesses in those communities. Ann Arbor's not one of those communities, so I would say the benefit is happening on a statewide level to some extent. If we wanted to incorporate it into the city, it would probably be through some sort of scoring metric.
And if I can add to that, it certainly is within the council's discretion at some later time to make a decision that more facilities are needed for the community, in which you would just raise the cap at that time.
And, okay, and another, maybe you can explain the logic on this, is there's some, it seems to me like a party store that's already selling liquor would be a natural fit to also sell marijuana too. But what's the logic or between those that being excluded that way?
I might
Right,
have
cigarettes, liquor.
Mr. McDonald follow up, but I think the state law provides some restrictions on the co-location of any business selling liquor and marijuana. So to that point of really setting state requirements so that the operations are distinct and can be tracked in a very specific basis, the state provisions are going to really constrain the ability to do that, probably until I would further, and all the people behind me know this more than I do, but there's probably also potentially some challenges on the financial institution to integrate those uses too much yet until the banking industry sort of catches up satisfactorily to the marijuana market.
Okay, yeah, that's, so there's no little workaround where we'd let them be separate but still on the same premises?
Still proposing similar districts, commercial districts, where that sort of retail exchange of goods would happen, but probably distinct uses.
And, okay, distinct uses. So just in closing, I wanted to piggyback on Councilmember Griswold's comment about marijuana having a positive effect potentially on our opioid crisis. Maybe some of our public speakers will speak to this, but I understand just a couple, 3 weeks ago, there was a conference here in town about psychologists and social workers using some new guided therapy sessions. That was apparently a very inspiring and exciting conference, and had a lot of promise for mental health services. Thanks.
Thank you. Thank you very much. And thanks to staff for the presentation today, for the conversation, and in all honesty, for the work to get us to this point. It is a fast-moving and complex and opaque environment in which we operate, and I know staff responded to many of our concerns that we do get something on the table to discuss, and they did so, and I'm grateful for it, so thank you. We now come to public comment general time. Public comment general time is an opportunity for members of the public to speak to council and the community about matters of municipal interest. To speak at public comment general time, one need not have signed up in advance. Speakers have 3 minutes in which to speak, so please pay close attention to the time clock. As a matter of courtesy, we may have only one person speaking at a time. And finally, if you require assistance in speaking before council today, we'd be delighted to provide it to you. Is there anyone who'd like to speak at public comment? Please just walk on up. You don't need to be recognized.
Evening, Mr. Mayor and City Council members. My name is Hugo J. Mack, and I am a candidate for Washtenaw County Prosecuting Attorney in 2020. I'm here because I am touched by what Councilwoman Griswold said about the positive effects in terms of marijuana, what it can benefit us in. People that are in tremendous pain as opposed to resorting to morphine, and I'm understanding of that. But the next Washtenaw County Prosecuting Attorney will be the Chief Law Enforcement Officer of the county. And that, should the voters decide to be me, means I will have to enforce laws. And what I'm concerned about is that as we progress in fulfillment of the voters' decision last November, are we going to look at public education, for example? There are some people, as a practicing attorney, I can tell you, who think because they have a medical marijuana card, that means okay for them to smoke marijuana and drive a vehicle, regardless of the amount of THC in their system. That is false. There are some who don't understand that marijuana is still a Schedule I federal offense, right on line with LSD. A lot of people do not understand this. So what I'm concerned about is, not only in terms of looking at the county prosecutor as one who enforces the law, but primarily as a minister of justice, responsible for justice for the 325,000 residents of this county, including all of you and your families. So what I'm concerned about is, just as in any other substance, there can be abuse. We have over 3,000 statutes now in terms of criminal activities. And I'm concerned if we're actively engaging in public education to let people know you can't just go in and consume and think you can be disorderly on the streets and then pass that off on a medical marijuana card or for public consumption, for recreational use. Now, the concern I have is that, for example, as I believe Councilwoman Griswold stated, in terms of the use of it, in terms of people that are incarcerated now for something which is now being legal, I am concerned about individuals having an opportunity to re-enter into restorative justice. I'm concerned about that. But I'm also concerned about the public education piece, because I really don't want citizens to be misled into thinking that it's just an open area, it's an open field, it's an open opportunity, because I will enforce the law. And so I'm asking and I'm reaching out to City Council to be sure that we have public education in this also. I mean, there is an offense, driving under the influence of drugs. So I'm asking for help for whoever the next county prosecutor would be. Hopefully it will be me. But we must protect the citizens, and education is the key to protecting the citizens. Thank you so much.
Thank you. Is there anyone else who would like to speak at public comment?
Good evening, Brian Fennick. I appreciate the time to speak this evening, and I appreciate the special working session this evening as well. It's obviously an important topic, and it's important for the city as a whole, because if we're truly going to have a regulated market in this town, we need to flesh out some of these issues. Not so much the opting in or out part, I think that is somewhat clear at this point, but to echo some of what Council Member Rumlawi has stated, I think there are some economic and social equity issues that the cap kind of has an impact on. And if we're going to sit and have a number of 28, which I believe was set at 28 primarily because that's the number of applications that were in at the time that that amendment to the original ordinance was passed. So, so that's really why it was at 28 at the time. But if we're gonna have a true, robust market in this town, a regulated market in this town, then we have to kind of think about opening up some of those caps, especially if we're going to say that you can have combined consumption and cap the consumption facilities and the micro businesses at 28 as well. If you only have 28 businesses that are going to have permits, provisioning centers, then it's realistic to think that those are the only numbers that are going, those are the only permits that are going to apply for the consumption, the combined consumption facilities. So in other words, there's really you're really not opening up much of anything in terms of the provisioning center combined with a consumption facility. And a standalone consumption facility truly aren't really, they're not really that valuable from an economic standpoint. And then finally, speaking about SEUs, what we've seen is that they've been commoditized by the cap. We've seen some locations where an SEU has been acquired and it's been sold up to 2 times, and they're just leases. They don't even own that property. So by, again, creating the cap, you are creating a bit of a monopoly for those that are operating right now, and by not opening it up, you're really not creating a robust regulatory market. You're inviting a more robust black market, so to speak. And then finally, I would like to say that I believe at the council meeting last week, there was some discussion about opening up the co-location of provisioning centers and consumption facilities to more than D1 and D2. And I believe there was an amendment that was proposed, but I don't think that amendment was ever voted on. So I'd like to just remind you all to maybe go back and look at the record and see if that was something that needs to be addressed. I don't know if it was an amendment that was proposed, but I do think that D1 and it should be opened up beyond that, as well as increasing the cap. Thank you.
Thank you.
Good evening. My name is Diane Gianola, and I live in the 4th Ward. I was taken by surprise last week when marijuana consumption facilities were added to the proposed ordinance for marijuana retail stores. The ballot proposal that was passed last year simply asked for legalization of recreational marijuana and for commercial sales to state-licensed retailers. Nowhere was it mentioned or even discussed that consumption centers or use centers could be or would be established. These consumption centers are a danger to the safety of all of us on the roads. Every customer that visits a marijuana consumption center will leave high or buzzed and will likely get into a car to drive home or around town. All patrons who leave these establishments high and drive are a direct safety risk to the rest of the residents of the city. Marijuana is not like alcohol. It is a false equivalency that alcohol use and marijuana use are the same. They are not. You can go to a bar or restaurant and have only one alcoholic beverage with or without a meal. You don't have to get drunk, and most don't get drunk after visiting an establishment with alcohol. The primary purpose is simply enjoy a beer with friends or a glass of wine with a meal, for example, not to get drunk. The vast majority of people who leave bars do not leave drunk or are impaired drivers. It is the abuse of alcohol, not the use of alcohol, that is the problem in relation to driving. The vast majority of people who leave consumption centers or marijuana cafes will be impaired drivers. The only purpose of a marijuana consumption center is to get high. You don't go to enjoy the aroma or the taste of pot before it actually gets you high. You don't go to simply take one hit off a joint. It is the simple use, not the abuse of marijuana, that is the problem in relation to driving. You don't have to abuse marijuana to get high and become an impaired driver. The city can't assume that because the ballot proposal that legalized the private use of marijuana passed, that everyone will now be fully on board with allowing marijuana consumption centers around town. The ballot proposal that voters approved mentioned nothing about consumption centers or temporary marijuana events. Why is council now trying to slide this through when the public thinks that you guys are simply talking about regulating and zoning the retail shops? I ask that you simply pass the regulations and zoning for the retail shops as expected and discuss the consumption centers at a later date. There are so many issues that need to be discussed in relation to these consumption centers. Parking, there should be no parking at these centers, period, so not to encourage impaired driving. Liability, if a bar overserves a customer that leaves and kills someone, then the bar can be held legally responsible. How is this enforced at a consumption center? Every person will most likely be an impaired driver leaving the place. Will the city be responsible because it allowed parking at this sort of place, knowing full well of the safety risk? There is no drug driving test that can be implemented on impaired drivers. How do you prevent high driving? I am appalled that this is being slipped through without community discussion on this. I ask that you remove any consideration of marijuana consumption centers and temporary marijuana events in these ordinances. Both of these are risks to the public safety if you can't control impaired driver behavior. Thank you.
Thank you. Is there anyone else who'd like to speak at public comment?
My name is Charles Ream, and I'm very privileged to be able to speak to you this evening. We all know that the state Commission on Driving just finished up and found no connection whatsoever with the amount of THC and impairment. It is mostly a question of practice or experience. The people of Ann Arbor were ready for these social consumption centers in 1972. People of Ann Arbor have waited 50 years for this. To say that there is some kind of hurry or rush, or we need a bit more time after we've waited 50 years, is kind of an insult to a lot of us. Alcohol is deadly, and many people in my family are dead from it. One cousin was born retarded with hair growing all up her back. People deserve to have as many options to use and purchase healthy marijuana as they do to purchase the poisons of tobacco or alcohol. There's got to be equivalence, and there can't be any prejudice against food. If you prohibit food, you're just encouraging sort of a drug experience. If you allow food, you're encouraging a complete cultural experience. One thing I found just fascinating was the curfew, the 9 o'clock curfew. Here in my life, I've never been able to go out and socialize because I cannot drink alcohol. I simply cannot do it. I can't get near cigarettes at all because they make me really sick. So I've never been able to go out and socialize. And so now I will be able to go out and socialize, but I'll have to be home by 9 o'clock because that's the curfew. In East Lansing, they say 10 o'clock. A lot of people, not just in Argentina and Spain or something, but lots of Americans even aren't done with dinner till 10 o'clock. Come on, folks, we could at least make it a midnight curfew or something, and it should be the same as alcohol. Anyway, not 9 o'clock. Come on, boys and girls. And we know the police and fire reports. You've all been here for the police and fire reports. The police department and the fire department always say that these establishments are just fine and not causing any difficulty whatsoever. You should really think about this 10% energy offset. That takes a lot of energy to grow cannabis. They're never going to be able, I don't think, that just by putting solar panels on the roof, you're going to be able to get 10% of your energy use. This would probably prohibit any growers from locating here because their costs would be so much higher. And maybe you know the data already about marijuana establishments. Crime goes down anywhere near marijuana establishments because there's usually a lot of security. Property values go up near any marijuana establishments. We don't need any problems with proximity, too. We need to let these things exist. The Ann Arbor voters want them and want them now. Thanks.
Thank you.
Hello, good evening. My name is Kenneth Bryan with Medicine Man of Ann Arbor. We were grandfathered in as a temporary operator by Ann Arbor. We are a compassion-driven business and love operating in Ann Arbor. My father and I both attended the University of Michigan and fell in love with Ann Arbor. We also been selected as a business rep for the State of Michigan Social Equity Program. The dilemma we face is the unwritten rule of the SCU cap of 28. The cap of 28 dispensaries was very clear in the ordinance. However, the SCU cap is unwritten, and it greatly harmed us on our approach to move our business. We went through the process of obtaining both our state and city license as a provisioning center. Our approach was to obtain one of the 28 permits by the city and then move our license. However, when we attempted to move, we were told that we were unable to move to our new green zone location because the planners decided to cap the SCUs as 28 as well. This hurt businesses such as ours, and it helps, and it had us to lose our protection of our license. By capping the SCUs, you essentially attached a city dispensary permit to the location and not to the business. This pushes corporate greed in and pushes your compassion-driven businesses out by not allowing a business such as ours to move and keep our current active permit. We ask that this is corrected by not capping the SCUs or to at least allow a business with both a state license and city permit to seek an additional SCU in order to move our business and not lose our hard-earned license. We collected hundreds of signatures supporting our attempt to remain active here in Ann Arbor. We ask that you look at the ordinance or the unwritten rule of the SCU as well. Thank you.
Thank you. Is there anyone else who'd like to speak at public comment?
Good evening, and thank you for your time. I actually didn't expect to make any comments tonight. But as this meeting's gone forward, I think it's become clear that there are a lot of questions about how, not if. I think it's obvious that Ann Arbor will allow recreational marijuana businesses to proliferate in the community. But I think we're left with the big how question. How do we implement this? What is the correct way to implement this? I don't want to tell you how to do your jobs, but I do remember that when we went through the medical marijuana ordinance review, we had a whole review commission. I believe Councilmember Smith was on that commission. I believe Mr. Lenart was there many a times. It's hard for me to remember who else was there. But we did have that type of commission. We had a lot of community input, and we had all those things before we crafted that medical marijuana ordinance, which, looking back, has turned out to be a pretty good ordinance. I don't think you have an easy job here, and I think you have a lot of competing things from all the individuals here tonight. But I would make a proposal that we do want to do this fast. I think it's obvious. Everybody in Ann Arbor wants to have recreational marijuana and wants to have it November 1st. I think that's come through loud and clear here tonight. I would propose, though, that our council look at this and realize what's going on, maybe look at our already licensed medical marijuana provisioning centers, allow them to go into recreational medical marijuana provisioning centers as licensed, and then take the time to completely craft this ordinance moving forward. That way we can have what we want, which is fast, which is some recreational marijuana available in Ann Arbor on November 1st, on the first date that we can absolutely have it, and actually take the time to craft this ordinance and make sure that it meets all of these competing needs that everybody has come out here tonight. Thank you.
Thank you. Thank you.
Good evening. I'm Kelly Wakovich. I am a mother of a toddler in Ann Arbor, as well as a practicing pediatric oncologist here in the city. In review of the current recreational marijuana draft, I was kind of surprised and taken aback at the lack of detail for a city that has prided itself on being a leader in this area and has waited 50-plus years for this to come to fruition. I was surprised by the lack of substantial details and the apparent paucity of community engagement, which I think we've heard echoed tonight. I am encouraged by your comments today. It seems like many of you have asked relevant questions, asking for a board, asking for speed and resolution and equity to our colleagues and businesses. My concern is really with the addition of the designated marijuana consumption facilities and the micro businesses. The arbitrary cap now increases the places where marijuana is readily present to the public in the city at 84. That's 3 per every square mile of the city. This appears to be done without consideration of the potential negative impacts on children, specifically the younger children in our community, as well as recovering addicts, without input from parents or the community. I'm less concerned with the overall number and more concerned about preserving a safe and comfortable environment for the families that live here, as well as the recovering addicts who deserve a safe space. And while council largely disregarded mine and my medical colleagues' concerns last fall while discussing the medical marijuana restrictions, which asked for a 1,000-foot buffer that is currently afforded to the K through 12 schools to be expanded to daycares and addiction centers, which we're still asking for, by the way. I am curious if you may be more moved, given your realm of politics, by public opinion. So before you is the mock poll on parental attitudes and their wish to be communicated with regarding marijuana use. This was done by the mock poll, as you may or may not know, is actually a large national demographic that follows a bunch of families in different areas of the country, as well as different financial and other entities, but is reflective of our Ann Arbor community. And in that survey, 74% of parents wanted a restriction between medical marijuana facilities and schools, and 68 also wanted that same restriction with daycares. It's been brought up before whether this would be feasible, and I would say to you that it is feasible. We've seen it in small communities as Forsyth, Minnesota, to more moderate like Boulder, Colorado, and even to large-scale cities like Los Angeles. And so I'd ask you not only to consider it, but also to be careful to engage parents in the medical community in a more meaningful way. Overall, I think there are many questions to be answered. I think a board would be helpful. Some questions, more details, and I really urge you to consider just a temporary. You've waited almost half a century, a couple more weeks probably to get it right would be valuable. And this is to really be inclusive, to have a robust set of regulations, to provide clean and equitable expectations to the businesses, and to maintain safety for our members. Thank you.
Thank you.
Good evening, and thank you so much for the time and attention that you've spent on this. I know that, this is a time-consuming issue any time it comes before the City Council. My name is Allison Ireton. I live at 865 Wickfield Court in Ward 1. I'm also the attorney for Bloom City Club, which is located at 423 Miller Avenue. And I know many of you sitting up here because I went through that process, the MMFLA process about 1.5 years ago. I just wanted to make a comment. I wasn't planning on saying anything. I was just, in the neighborhood, so I stopped by rather than watching from home. And Mr. Jofe, the attorney who spoke 2 speakers ago, brought up an interesting point. There seems to be a compromise available to City Council that if City Council is unsure about having 28 consumption centers and 28 micro businesses, that there are permitted and licensed and operating medical facilities currently in Ann Arbor that you could, to the extent that, staff and the attorneys tried to just mirror what currently exists and overlay the MRTMA or recreational rules on top of that, you could allow permitting for those existing facilities and have notice very little change in the community, and then have the public appearance of Ann Arbor with all of our rich history of supporting these kinds of movements and this cause, Ann Arbor's all on board, and then roll out certain other pieces of this at a later time after more consideration has been given to number and limits and where and how. And that's what kind of moved me to come up and speak. It sounds to me like that's an interesting compromise that I didn't hear previously. And I also heard a lot of comments tonight about, how property value goes up when one of these things gets licensed. And I mean, that's happening all over the state. When Amazon moves into Virginia, property values increase. I mean, that's just something that happens when new industry moves in. That doesn't make it good, it doesn't make it bad. It doesn't make people bad if they want to acquire these properties or flip them to somebody else who's willing to pay more so that they don't have to operate the business. And I can tell you that operating one of these businesses is not easy. It's very attractive to a lot of people to flip these to somebody else who's been doing it for a long time. So I just want to caution about making any judgments that that's a good thing or a bad thing, that property values go up and that people want to sell their business. So that just leads me to my final thought, which was on a cap. As Mr. Leonard said, we have 28 permits currently available and only 13 or 15 provisioning centers are even open. It might be interesting to see what it looks like when 28 are finally open to see how that, whether the cap should be raised. And if the cap is raised, what is it, 30? And then there are 30 people that have a monopoly or 32 people that have a monopoly. Number 33 or the next person is always going to think that the previous ones have a monopoly. So thank you for your attention tonight, and thank you for being here.
Thank you. Is there anyone else who'd like to speak at public comment?
Hi, everyone. My name is Lisa Conine, and I'm the Community Outreach Coordinator for the Home of Medicine, a medical cannabis provisioning center located on Main Street. I'm here today to express support for not only a sensible adult use ordinance approved by the November 1st timeline that the state has given, positioning Ann Arbor once again as a continued leader on this front, but also for sensible policy surrounding designated consumption spaces. As Community Outreach Coordinator, I interact with the public and our patients frequently regarding their cannabis use and their desire to have a communal space to do so. It's imperative that the ordinance passes along with the state's timeline so we can implement the system as soon as possible. At our facility, we have a lounge where we host a number of events in-house as a way to educate on cannabis and create a fun and safe community feel. A number of you have visited our facility and have witnessed this yourselves. It's only the natural order to have a space for community events and education to include the consumption of cannabis. Our community is ready for this now. As stated before, those unable to consume in their own home due to renting or living in public housing need a place to consume cannabis, and one that isn't in the back alleys, public parks, or pushed to the outskirts of town. The fact that people who do not own a home are unable to consume cannabis without fear of penalty is discriminatory. Those individuals deserve this ordinance to be put in place in a timely fashion. We also want all individuals to have access to a healthier option for socializing and consuming something of their choice. We believe that having designated consumption lounges will allow for adults to consume cannabis without shame. At this point, it's safe to say that we all know at least an acquaintance that consumes cannabis as part of their healthy lifestyle, and it's time to take the shame out of that choice. It is time to normalize cannabis. In our lounge and our facility, we have proven the cannabis community to be a compassionate one. Our patients have given back to the community tenfold through a number of community initiatives that we have in place, including earning breadwinner donor status for food gatherers, which comes from our patient donations. Our monthly comedy shows are a huge hit, and we like to say that laughter is the second best medicine. So imagine a comedy show where adults can consume safely at the venue, and imagine pairing that event with a fundraiser for a local nonprofit in the community, perhaps an addiction center. The possibilities are endless. And on the note for the need for public education, I want to speak to that. The Washtenaw County Health Department has received a grant from the state to educate the public on cannabis use and driving specifically, and they actually consulted us to help them with that education. So I would encourage anyone looking to educate the public on this to actually consult people who have been working with cannabis consumers for years. So again, as stated earlier, Ann Arbor has led on this issue for the last 50 years. So let's show how we can be a leader in this and be compassionate and sensible in our approach. Thank you.
Thank you. Is there anyone else who'd like to speak at public comment? Seeing no one, public comment is closed. May I have a motion to adjourn, please? Moved by Councilmember Smith, second by Councilmember Nelson. Discussion. All in favor? Opposed? We're adjourned.